Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk. Okay, legislative session just ended, 2025 edition. And a few new laws and rules that are, I guess at this point, they're all laws that the legislature deals with. So let's talk about one of them. We'll break them down. Maybe we'll do a couple videos. But this one is kind of interesting. We've always been, especially with the rule changes due to the settlement, where's the line when I'm approached as a listing agent? I'm approached by an unrepresented buyer. Like, what can I do? What can I do? Can't I do? So I didn't feel like there was a great line in the law of where you're going too far. And so the legislature passed kind of a safe harbor rule or law. And it says the following conduct by a principal broker who represents a seller. And when we say that in the law, the principal broker, I think in this case we could look at it as it extends to the agent under the principal broker because they're kind of acting on behalf of the principal broker. Okay. So the following conduct does not create an agency relationship with a buyer unrepresented by a principal broker. So unrepresented buyer, what can you do that won't create an agency relationship with that buyer? Number one, contacting the buyer directly to discuss items related to the real estate transaction between the seller and buyer. Okay, I mean, that seems like common sense, but it's now in the law. Like, you can reach out to that buyer directly and conduct the sale. Number two, providing the buyer with blank forms. Okay, so this has been a hot topic for a long time. Can I give forms to an unrepresented buyer or seller? I guess in this case we're just talking about buyers. And this, yes, you can. Under this law, you can give blank forms to a buyer. Now, here's where I'd caution you. There's a difference in providing a blank form and advising, right? So if I advise the buyer on how to fill out the form, then I may be going too far. I think, in my opinion, you're going too far. You're now kind of representing them, right? And your fiduciary duties are to your seller. And so I wouldn't get into the forms of, okay, put this here, that number there, do this and that. I think you can really kind of overstep the protection of this because you're not just providing the form, you're actually helping them fill it out and advising them on it. Okay, number three, negotiating the terms of a real estate transaction between the seller and the buyer. Okay, so that means you can go as far as negotiating, which again kind of makes sense, but always kind of a hesitancy on, well, this is an unrepresented person. Now, what I'd recommend is giving them the unrepresented buyer disclosure. So, hey, I represent the seller. Anything I tell you is on behalf of the seller, in the seller's best interest. And that's just, you got to know that. So if I throw a number at you, it's a number that's good for my seller, not good for you, buyer. You have to look out for your own best interest. But hopefully this goes far to help protect listing brokerages and agents when they're dealing with that unrepresented buyer. So you can, with the forms, I'll add one more thing. Sorry, a little out of order here, but there are state forms, and then there are other forms. State forms are public, and you can give them to anybody, right? Anybody can use them. The other forms are probably realtor forms, and those are copyrighted. So you need to make sure the form you're using is okay that you provide it to someone who's not your own client, because that's generally how the copyright works, is you get to use it on behalf of your own client. And maybe we'll grab Craig Wagner from the UAR and do a joint video and kind of talk about that. That would be a fun one. But so there is a difference in where you're getting the forms from and how they're treated. Remember, this is not legal advice. This is legal information only. If you need specific legal advice, please contact your attorney. Thanks for tuning in.